Welcome to a special edition of Legal AF. I'm Karen Agnifilo, and I'm joined today by Danya Perry, who's an amazing ex-prosecutor, current lawyer, close friend of mine. And we are going to talk about and break down all things indictment, all things Trump, all things that's going on. And so we're really excited to be able to explain to everybody exactly what's happening because so much is going on. It gets really confusing. So let's just talk about where we are. There are so many court cases going on involving Donald Trump that it's hard to keep track of them all. And what's really confusing for some people is that there are both criminal cases and civil cases. Now, what's the difference between a criminal case and a civil case? A criminal case is something where it's brought by the government and by a prosecutor, whether it's a state prosecutor, a local prosecutor, or the Department of Justice, if it's a federal prosecution, and somebody can be punished by the government and they can go to jail or prison. That's what criminal is. And you have a criminal record and a rap sheet. And you're going to say to me, but wait a minute, I don't understand. There are some cases being brought by the government, i.e. attorneys general, like Letitia James, who is the Attorney General of the state of New York. And she has a case against Donald Trump, his sons, because remember, Ivanka Trump was taken out of that case. And that's a big case starting in October here in New York. And that's a big civil case. So that can get really confusing, right? How can the government bring a civil case? Now, a civil case is different than a criminal case because that can be brought by usually a private person or a private individual, but also sometimes the government, like an attorney general. And that case is civil, meaning the only penalties can be things like monetary penalties or other sanctions and restrictions on doing business in New York, but not jail or prison. And there's no criminal record associated with that case. There's another civil case, too, that just happened in Michigan, where the Michigan Attorney General brought charges against 16 fake electors. Now, that was a criminal case, right? So attorneys general can bring criminal cases and civil cases. So then there's other civil cases against Donald Trump, right? E. Jean Carroll has brought 2 civil cases against Donald Trump. And there's E. Jean Carroll 1 and E. Jean Carroll 2. E. Jean Carroll 2 happened already. We're waiting now for E. Jean Carroll 1 to go. So there's criminal and civil cases. And like I said, it gets very confusing. And then there's yet another civil case involving the Trump family coming up this fall, involving a scam that they perpetrated on people as well. So, so let's now talk about the criminal cases, not the civil cases. But again, it's confusing because timing wise, we all know you have Popok's whiteboard, right? That he puts up with the dates of when cases go. The first case we have going is this fall, is that case I just talked about in the state of New York, the Attorney General, Letitia James, and that's supposed to go in October. Then let's talk about the criminal cases that we have coming up. We have the Stormy Daniels case, right? That was brought, the case involving the hush money payments while he was president of the United States. That case where Judge Alvin Hellerstein in federal court just recently removed the case back down, or Trump removed the case to federal court saying, I don't want to be prosecuted by Judge Merchan and Alvin Bragg in state court. I'm the ex-president. I want to be prosecuted in federal court. So he went to federal court. He asked Judge Hellerstein whether he'll take the case federally. And Judge Hellerstein just wrote a scathing decision, basically saying to Trump, no, this is criminal. He used language that basically said, I find that there's evidence that he committed these offenses and it belongs in state court because this was entirely personal. This was not anything involving his presidency or under the color of law, federal law or federal defenses, even though he was president when he sat in the Oval Office and wrote those checks to Michael Cohen, who was his personal attorney at the time. So that case where Alvin Bragg is prosecuting that is scheduled to go in March. And then this week, Judge Eileen Cannon, who's the federal judge overseeing the Mar-a-Lago criminal case, in Fort Pierce, Florida. She just ruled that that case is going to go in May of 2024. So we got a lot going on in the Trump world. And we also know that there are two more indictments coming, right? Fani Willis, a state court prosecutor in the state of Georgia in Fulton County, she is expected to bring a sweeping RICO indictment in the coming weeks, potentially in late July to August. And she's already sworn in a grand jury there. And Trump, again, has been trying to, he went straight to the Georgia Supreme Court to try to get them to say, oh, let's disqualify her. Let's disqualify the judge. Let's not let her use the grand jury report of the special grand jury that, just sat and took testimony and heard evidence. But so that he's trying to do that, but that's going full steam ahead. And we think she signaled to the world, she said it was because, for security reasons, she wanted to let people know when this indictment's coming. But I think it was also a signal to Jack Smith so that if Jack Smith wants to go first, he can. And so Jack Smith sent out a target letter to Donald Trump last week. And Danya and I are going to break down all things that are about that target letter, the Jan 6 indictment that we think is coming. And so I just wanted to frame the context of what we're talking about and where we are. Danya, did I forget any cases with the Trump case? Like I said, they're hard to keep track of.
You did forget one on the civil side that is actually near and dear to my heart, which is the $500 million civil lawsuit that the former president brought against my client, Michael Cohen. The two have wrangled famously many times before, and they will be up against each other in the district attorney's case out of Manhattan. But in this case, the former president brought this lawsuit against Mr. Cohen and then did what he tends to do, which has been his most successful and most frequently used defensive gambit. Now he's using it offensively, which is just to try and put it off. So he brought the case and then refused to provide a date for deposition. And just a few days ago, the judge in that case in the Southern District of Florida ordered him to appear for deposition within 45 days. So that's just one more item on the calendar that is going to have to be balanced. I will be deposing the former president in a matter of now, I guess it's 43 days.
Wow,
so busy docket for Mr. Trump.
Yes,
but I think you got it. There are two civil cases in the middle of all that. But as you said, good to focus first on the criminal cases, which will take priority, of course, and all the juggling that the various judges are going to be having to do in terms of actually sequencing and scheduling all of these cases.
Yeah, and typically, right, the judges will talk to each other and they will decide, right? It's not up to prosecutors or defendants. The judge is the one who controls when a case goes, right?
It's highly discretionary. Usually it's the court's calendar that will decide. I mean, typically judges, they may talk amongst themselves and try and work out, as a matter of judicial politeness, how these will all get sequenced. Typically it is the first filed will be the first tried, but not always. I represented Michael Avenatti in a first filed case. This was the extortion case that was brought in the Southern District of New York, alleging that Mr. Avenatti had tried to extort Nike, which I thought was legally very, very aggressive case. But at the time, I didn't know that there were several other criminal investigations, and those ended up getting scheduled just according to the various judges' calendars. So that is typically how it happens. But the criminal cases will take priority over the civil ones, even the ones that have already been filed and have already been calendared. Almost certainly, if it, depending on what works best for the various judges' schedules.
So, the Fani Willis Georgia case is in some ways very similar in terms of the scope and nature of what she's bringing, right? She's bringing a big sweeping RICO case, at least if it's the way people have been reporting, with the nationwide slates of fake electors and this, big kind of conspiracy to overthrow the election, et cetera. And that's similar to what we think Jack Smith is going to bring. What do you think about two prosecutors bringing overlapping cases, one state and one federal?
So interesting. I've seen it happen many times when I was at the Department of Justice. There would often be turf wars between different U.S. attorneys' offices, and that would usually get resolved from on high, someone very high up at the Department of Justice. Here you've got two different sovereigns. And I think the idea here is, and I don't know that this has been articulated, but at least in my own mind, it makes a lot of sense because it's in a way a belt and suspenders. If it in fact Mr. Trump should win re-election, I think many of us are highly skeptical that the federal case will in fact, if it already has proceeded, that it will go forward. There's appeals, and in this one there probably will be it may ping pong up and down the circuit. But in any event, it seems, I would say, likely, given, if past is precedent, that there may be pardons in that case if in fact there are, if it goes, and if there are convictions. Obviously, there are a couple ifs in the way. There can be no presidential pardon at the state level. So if the DA in Fulton County moves forward and if she secures indictments and then convictions, it will be impossible for the president or his Department of Justice or his administration to really have much to do with changing the jury's verdict there. So
Yeah, I agree with you. Like on the one hand, it's like, let Jack Smith go, don't step on his toes, don't screw up his case. But on the other hand, it makes him pardon proof. So I lean on the side of, I think it's a good thing for that reason.
yeah, I'm with you. And we don't know, right? We think we know exactly what the contours of each of those indictments will be based on, witnesses who have spoken about their testimony or leaks to the press. But there were certainly some surprises in the first Jack Smith indictment on the Mar-a-Lago document case, and I suspect there will be some. And should there be another indictment from the special counsel's office?
Explain why we don't know. Like explain grand jury secrecy if you can.
Yeah. Yeah, well, it's just that. It is secret. There are rules within the code book that require secrecy so the grand jurors can't speak, the prosecutors can't speak. No one on that side of things can speak. Witnesses are permitted to talk about what they were subpoenaed about and what testimony they gave. Oftentimes they don't, for their own prudential reasons, but that's one of the ways that we've been able to get some breadcrumbs about what's been going on. The press has been, very on top of that, of the grand jury proceedings, waiting outside the courthouse and seeing comings and goings. And certainly there have been leaks, we don't know where from, but that more often than not have proven out. So, but generally, I mean, it is a crime at the federal level to spill grand jury secrets, and so we really don't know, everything that eventually will come out.
Exactly. But we did hear about a target letter, right, that was sent to Trump. And what can you just explain what a target letter is? And when you were at the Department of Justice, because I was a state court prosecutor for the better part of 3 decades. I worked at the Manhattan DA's office, and ultimately I ended as Cy Vance's chief assistant. That was not a practice at the Manhattan DA's office to send out target letters. Can you explain what a target letter is, and did you send them out, and when do you send them out? Do you always send them out? Just could you give a little bit of a framework of that?
So I was in the Department of Justice for 11 years, and towards the end, I was chief trial counsel at the Southern District of New York, and then deputy chief of the criminal division. And so I had a very good handle on the issuance of any target letters. And I cannot, sitting here today, think of any that we sent out. I believe Department of Justice during my tenure may have sent some out. They are actually quite rare in my experience, and anecdotally, there's no provision for that in the Department of Justice manual. It is more common for a prosecutor to advise defense counsel what status his or her client will have. And there are three main categories. It's target, subject, or witness. Witness is someone who has no exposure and is purely a bystander, for example, is kind of the classic example of that. Subject is someone who's loosely involved in the conduct. And it's almost like the prosecutors are not sure yet or not committing yet as to whether that person will be a witness or eventually a target. And a target is the final one, and that's essentially a putative or a likely defendant is really the focus of that criminal investigation. So that's pretty typical for a defense lawyer to ask the prosecutor and for the prosecutor to let that lawyer know, and various decisions are made depending on that classification. So there is certainly precedent for sending a target letter. In this case, where you see the special counsel's office going above and beyond, crossing every T and dotting every I, that where there's a case where the target is generally aware, and of course, I think everyone on the planet has generally been aware that there is a pending grand jury investigation, they will go out of their way, I think, to provide a target letter in the absence of, just to avoid any doubt, and to provide the opportunity for that target here, Mr. Trump, to either come in and meet with a grand jury and provide his defenses, which, as we understand it, he declined to do, or to make a pitch to the Department of Justice or here the special counsel's office as to why he should not be indicted or why certain of the charges don't fit or stick. Here we have heard that happened in the first Jack Smith production, the Mar-a-Lago indictment. We've heard that it happened in the DA's office case, I believe. We've not heard that it happened yet. And so you and I could probably get into a conversation about what that means timing-wise. Probably means either that Mr. Trump has decided not to send his lawyers in there, given his track rate, or it's going to be a little bit longer because he's going to take advantage of that opportunity. It just hasn't happened yet. I don't know what you think about that.
Yeah, I mean, it's interesting because we find out most things from Mr. Trump, right? He's the one who, tells us and informs us of whether he was asked to surrender in a particular case or whether he got a target letter. That we don't get that information from law enforcement or from the prosecutors, which is good. They're not supposed to do that. But, I think if he wanted to meet with Jack Smith, I would assume he would have said something. And the fact that he's quiet makes me wonder whether, I thought, they gave him until midnight, according to Trump, they gave him until midnight Thursday to decide. So I thought we could see an indictment as early as Friday and potentially this week. But, maybe he's doing things differently and he wants to do it quietly this time. But we haven't heard, at least from him, that he's looking for an opportunity to meet with the Justice Department. We also heard from different defense attorneys representing Rudy Giuliani and John Eastman in particular, that they did not receive target letters. And you would expect those two, along with Mark Meadows and Mr. Cheeseborough, you would expect them all to be indicted potentially with Donald Trump on the January 6th indictment. And that makes me want to ask you a question about, do you think they're cooperating? Do you think they're going to be indicted? And an indictment can be, it's Trump, when you look at Donald Trump, he is like a walking criminal enterprise, right? Like his entire existence and life in some ways is lots and lots and lots of crimes. And so Jack Smith has a lot to choose from, I think. And the question, though, is he going to what's he going to do, right? Is he going to do a big, giant, sweeping indictment that encompasses all things, or is he going to be more focused and limited and narrow with charges and defendants? Because, you know, the more I mean, I know, I'm sure you, as I have done many kind of multiple defendant cases, the more defense attorneys schedules you have to wrestle, you know, into the ground, the longer it takes to get a case to go to trial, right? I mean, so one potential thing that Jack Smith is doing is saying, you know what, I really want to get a case that is discreet and will go to trial. And so I'm going to limit it to just Donald Trump, and I'm going to limit it to, you know, I know the target letter said 3 different charges. Talk a little bit about this whole thought process and where you land with all of this, and whether you think people are cooperating and et cetera.
Yeah, I'm thinking about it along the same lines you are. My best guess, and again, you know, we've acknowledged we're reading some tea leaves here.
This
My
is all
best
guesswork.
guess is they are, but based on between us, you know, many, many decades of experience. So I do think that they are looking for a relatively narrow, streamlined approach, much as they did with the Mar-a-Lago indictment, and are looking to indict Mr. Trump in this first, you know, this initial indictment. And that, but we also have read about or seen signs and reports that this grand jury will remain impaneled. We know about, for example, former Commissioner Bernie Kerik will be testifying in the coming weeks, and we've heard about ongoing testimony, which does imply to me that this grand jury is not going to be done with its work once it hands what we all believe will be an initial indictment in the coming, we'll call it days, perhaps weeks, but sooner probably rather than later, and that it will keep going. And I agree with you 100% with your reasoning that what the more individuals, more defendants you introduce into this charging document, the more complicated it all gets as a legal matter and really just as a docketing and a calendaring matter. And what they are going to want to do is hope that they get a no nonsense, you know, judge who will toe the line and make sure that, you know, this is tight and this gets calendared as quickly as possible and will move the case along and not have to deal with, you know, other motions or defenses or calendars. And so we'll keep it moving along. And it could be, I also agree with you, you know, certainly from some of the reporting, it is possible that some of those individuals are indeed cooperating, whether they have immunity, whether they have a non-prosecution agreement, whether they have an actual cooperation agreement. Either way, chances are, if they're not in that indictment, and again, I agree with you that they likely won't be, they may be in there not as named defendants, but as, you know, unnamed or unindicted co-conspirators, and that the special counsel's office will deal with them separately.
So let's break
That's
that
my
down
best.
a little. I agree with you. Let's break that down a little bit for people. What is giving someone immunity? What is giving someone a cooperation agreement? What is, you know, break all those things down for people from a prosecutor standpoint, and why you would do one versus the other, and just explain to people who haven't spent, you know, between the two of us, 4 decades worth of prosecution experience, right? We talk about these things like they're just, we all know what they are, but not everyone understands, you know, what those are and what different considerations go into giving each of those things.
So a cooperation agreement will be when you've got an individual who is involved in the criminal conduct. They are a co-conspirator. They have done something wrong and they are prosecutable. And they, along with their attorneys, have made the calculated judgment that it is in their best interest to plead guilty pursuant to, in the federal system, it's a 5K letter. That's just the statutory heading, but it allows them to hope for the best essentially at sentencing. So in that case, they will plead to all of the conduct, and then they will have to testify. Oftentimes, sometimes they don't, because the target or the defendant who's going to trial will plead, but they have to be prepared to do that, to provide all information to the prosecutors, not just about this conduct, but essentially it's just the prosecution will look under the hood, and any bad thing or embarrassing thing that that person has ever done will have to be provided to the prosecution. They could even be charged for things that were not within the purview of the initial investigation. So sometimes if there's a tremendous amount of criminal history, some of which is unknown to the prosecution, that target might decide not to cooperate because the world of the unknown is even worse, than the universe that's known. In any event, they have to plead to the conduct. And if they testify at trial, or if they're just cooperative and helpful and they give useful investigation, useful and actionable information to the government, they will get this so-called 5K letter in the federal system or cooperation agreement in the state system. And the judge will be advised, usually the warts and all, here's what this guy did, but here's how he helped. And if he provided useful information, he or she will get some kind of break at sentencing. And typically it is well worth having done. They will do a lot better at sentencing than they would have absent a cooperation agreement. But they have a felony conviction more often than not. And so that it really depends on their level of culpability and how dead to rights they are. And so we don't know. We have been hearing that individuals like Mark Meadows and Rudy Giuliani have been quote unquote cooperating. We just don't know. Does that mean that they will be taking a plea and securing a cooperation agreement? Or does it mean just the more colloquial sense that they're providing information and, trying to be helpful? So I guess that's at one end.
They don't get prosecuted, right?
They don't, or they don't get sentenced, that they don't have to do jail time at the end of the day. Because if they do, yep.
The one great thing federally that you guys have that we didn't have in the state is if one of them lies to an FBI agent, right? They can be it's a crime. It's a crime to lie to an FBI agent, and they can be prosecuted. They call it a 1001 crime, right? And they can be prosecuted for that. I had people lie to me and the police all the time, and there's nothing you can do about it. So,
those are some sharp teeth. Not only can they be separately prosecuted for lying to federal agents, but almost always that cooperation agreement will then be torn up and thrown away. And so that individual has exposed themselves to having provided all this information, some of which the prosecution might not have had, sometimes plead guilty to the offense, and then have that cooperation agreement torn up. They've just written their own ticket to a lengthier prison sentence than they might not have gotten if they've just pled straight up. So it's a precarious path, and you have to be really committed to it.
We'll see, right? What these guys, because Mark Meadows, Rudy Giuliani, John Eastman, I can't remember Cheeseborough's first name. They all, I think, are absolutely culpable. And so it'll be interesting. So another thing you mentioned is they could have been given immunity or a non-pros agreement or non-prosecution agreement. Can you explain what those two things are and when someone would give that as opposed to a cooperation agreement? Like, you've got someone in front of you, right? You're a prosecutor. You've got someone in front of you who has some culpability, and you have these options, right? As you said, there's like a witness who, if there's just an eyewitness, you don't have to give them anything, other than a subpoena. If they don't want to come in, they will come in and give information. You don't have to work out this deal with them in order to secure their testimony. But you have someone who's either a subject or a target, and that's somebody who's involved in some way, or is culpable, and you have evidence against them. And we know from the Jan 6 Select Committee that there is culpability on the part of those individuals. So you're a prosecutor and you have you want their cooperation, or maybe you don't care, but they want to come forward because they don't want to have the full hammer of federal law against them. You're a prosecutor, you have these tools in front of you. One is, I could give them full immunity, which means you just get away with it, right? You don't have to get any prosecution. You don't have to plead guilty. You have no criminal record. You are immune from any culpability there in exchange for your testimony. Or you just described beautifully what a cooperation agreement is. And then there's something called a non-prosecution agreement, which is similar to a cooperation agreement, but you don't have a criminal record. Basically, it's like a written agreement where you agree to provide truthful, full testimony, but you don't have to plead guilty. And so, we're just agreeing not to prosecute you, but we're not immunizing you. So if you don't give truthful testimony, or if you don't abide by the terms of this contract, we'll rip up the contract and we can prosecute you. And so why would Jack Smith, what do you think he's thinking when it comes to those individuals? Do you think, I don't think he would give any of them immunity. Do you agree with that, or what do you think?
Well, I agree with your assessment based on what we know, largely out of the January 6th committee hearings and evidence. Each of those individuals does seem to have some significant culpability. And so I would agree, if anything, it would be a cooperation agreement rather than non-prosecution agreement is usually kind of sleeves off a prosecutor's vest. It's if they don't really think that person has done anything wrong, but that person wants the security or the comfort to know that they won't get prosecuted. That's typically that. And it's not, that's not a frequently used tool. Immunity is different in the federal system than in the state court system. As you know, it's much more robust. When there's a witness in the grand jury, they will be fully immunized, whereas that's not the case. They can be immunized for certain narrow conduct, but not for, if they lie, for example, they can still be prosecuted for perjury if they testify falsely in the grand jury. And there may be other conduct that they could be prosecuted for. So it's not a perfect solution for a defendant who is concerned that there's criminal conduct out there that they want to protect themselves against. So here, yeah, my best guess from the information that we have, which we've acknowledged is incomplete, would be that the Department of Justice is looking for cooperation agreements from these gentlemen rather than any, giving them any kind of dispensation.
Right. I think you're right. But at the same time, I don't think they can tell the truth. I really, they have said so many times, I'm not kidding. Like when you look at their public statements, Rudy Giuliani in particular, all his public statements about, what Trump did and didn't do and what he thinks. He'd have to go back on literally everything and tell you can't just cooperate and lie. Like the Department of Justice isn't going to accept that, right? So I just think it'll be very interesting to see how this all shakes out. And when it all shakes out, I think you're right that I agree with you, or you agree with me. I don't know who now, but that this is going to be a streamlined case against just Trump. And I don't really know why they threw Walt Nauta into the Mar-a-Lago one. Maybe hoping to pressure him to cooperate, but there might be like another, Batman and Robin situation here, maybe one other person that they have to tag on to this indictment. But I could imagine seeing one where it's just Trump and it's just limited charges. Now, you worked with some people on Just Security and some others, which is an amazing organization, to write a model prosecution memo on what you think the charges could be. And so you really have done a deep dive analysis into the evidence and the facts and the charges that Jack Smith is looking at. Now, I want you to kind of take us through that. But before you do that, what is a prosecution memo? What colloquially is called a pros memo, and what did you do? Like, what is this thing you guys created? Because it's clearly not the pros memo, right? So, like, talk a little bit about what that is, and then let's dive right into the charges and the facts.
Yeah, at 264 pages, it's definitely bulkier than what a typical prosecution memo would look like. We wanted to just throw everything in there that we knew and make the best case for why we thought the charges that we selected would fit the facts as we understood them. So a prosecution memo, when there is a very either high profile or complex or publicly impactful investigation, the prosecutors, the line prosecutors, typically will put together something, this pros memo, which essentially lays out all of the facts that would support charges. They lay out the possible menu of charges. Because there are so many, and I haven't counted how many there are in the code books in the federal system, but there are so many potentially applicable statutes that on which you could hang, the same set of facts. And there are a lot of legal implications for which statutory framework you choose. So it lays out the facts, it lays out the potential counts, and then it will lay out potential defenses and also kind of rebut those potential defenses, and then just give the bottom line for the hires up, the decision makers within the Department of Justice, who ultimately will have to decide yay or nay. And so we started this exercise some time ago and just realized a couple weeks ago that it could stand some freshening up, because we've learned so much in the past months. And we all, as a number of former federal prosecutors and people who've been very involved in the space, Norm Eisen, I know a friend of yours, is one of the main authors, and he was heavily involved in the first impeachment proceeding. And it was just an all-star group of authors with tremendous experience. And we all kind of put our heads together to say, like, this is probably going to happen soon if it happens. And so we kind of redoubled our efforts and put together what I think is a very comprehensive and thorough analysis of the possible charges. And so that came out, I guess, last week. And, we're kind of patting ourselves on the back a bit, because we had a lot of it right. I think we've got, and look, we're not also, prognosticators. There's been a lot out there. So all we did was kind of marshal it together and put our experience, to bear in thinking through, where this might land. And it looks like from the statutes that are listed in the target letter that there looks to be, if there are charges, there will be some form of conspiracy to defraud the United States, which we can talk about, either witness tampering, there's been a lot discussed about this, or we believe more likely obstructing an official proceeding, which is the counting of the electoral vote on January 6th. We had thought there could be, although we kind of thought there might not be, but we believed that the facts and the law would support a count of inciting insurrection. And here in the target letter, we see deprivation of civil rights under color of law. Our collective thinking is, could be the same thing, the same set of facts, really the violence that we all saw to our horror unfold on January 6th itself. And that's one of those counts that could be dressed up any number of different ways. We thought it could be the insurrection incitement, but it looks like the way Jack Smith's team is conceiving of it, it's more this kind of Reconstruction era statute of depriving folks. We don't know who exactly. Many very smart pundits and legal analysts are supposing it means the electorate in general, but it also could be members of Congress, it could be Mike Pence, but it's deprivation of rights and privileges.
The 18 U.S.C. Section 241, right?
Right.
And wouldn't that be interesting?
What's that?
What?
And 242 is kind of the analog. One's a conspiracy, and one is just the
Yeah.
substantive count.
Yeah. So
Yeah.
18 USC 241 and 242 are interesting. And, if it's the way you just said, depriving the electorate, that's like 87 million votes or 87 million victims, I should say. Might be the biggest, the biggest case ever in terms of number of victims. That's crazy. So there were, in the target letter, there were three charges listed, right? There was the one we just talked about, 18 USC 241 or 242, and two other charges that you just talked about. Does that mean that those are the only charges that will be brought or can be brought, or is that typical? Like in a target letter, do they give just an idea of the charges, or do they give an exhaustive number of charges? Like, what can we glean from the fact that there were those three charges listed in the target letter?
It does not hold Jack Smith to charging exactly those statutes and only those statutes. Again, this is kind of an extra special gift, if you call it that. I'm sure it's not being conceived that way, but it's not the usual order of business to provide the target letter, and it's not going to bind the special counsel. It does, I believe, make it more likely than not that those will be the three counts in the initial indictment, at least. Whether there are superseding counts and superseding indictments, we don't know, but at least those will be in there. Maybe there'll be some others, like the 371 conspiracy to defraud count could also be, you mentioned the 1001, which is just lying, in an official proceeding or to federal agents. Those can be one and the same. They can be charged together. I mean, so there's different configurations, but I strongly suspect that those will be the three main charges, and it could
So let's
be more than one of each, right? The
right.
conspiracy could be, they're different schemes that the
So
January
take us
6th
through
committee laid
them.
out.
Take us through the three charges generally. Like, you don't have to go into excruciating detail, but just, this is the charge, this is what it means, this is what it means, and this is the conduct that would probably likely encompass that charge, just so people get a sense of what we're talking about here.
Well, so this is, our best supposition at this point. So the conspiracy to defraud the United States, we've heard about the January 6th committee did, I think, an incredible job laying out a number of different schemes that were discussed and operationalized in the months, weeks, and days leading up to January 6th. So I think they did a masterful job of framing all of this as going well beyond that horrible day itself, and having its antecedent roots, many months before, when the former president started saying, well, the only way I'm going to lose is if there's fraud, and well, I'm not committing to saying I will accept the results. And so that's when kind of the wheels started to go into motion, where a number of different potential schemes were being discussed and cooked up. And the one that we've all believed,
Fake electors, right?
the fake electors, it certainly seems like that's the one that has got, the legs to go the distance here. It's, there are quite a few, but this one, it's so, if you really take a step backwards, it's so brazen. It actually knocks me off my feet when you really think about what was done. And the Michigan case that you mentioned earlier, Karen, kind of lays it bare. Like it's hard to almost conceive of this, but the votes were cast for a certain slate of electors. In Michigan, for example, it was for the Democratic slate of electors, duly elected by the citizens of the state of Michigan. And there was this just shameless and shameful scheme by this other roster who just talked amongst themselves. They did it. It's usually when it's done in secrecy, right? So surreptitiously, and saying like, "Oh, don't tell anyone we're doing this." And certain of the folks who were on it originally decided not to do it because they realized that this was in fact a criminal scheme, according to these allegations. I mean, they would even call themselves fake electors, which is like such a gift, right, to a prosecutor. They knew exactly what they were doing. And they put their names down knowing that they were not the true electors. And then they submitted them officially to Congress and, to Mike Pence with the hopes of persuading them, or, the ultimate goal was to persuade Mike Pence to either pause a beat or to actually certify these fake false electors. It's
The
just
thing
really
about the Michigan case,
breathtaking.
totally. The thing about the Michigan case that really gets me is, if it was just the signatures, then they could say, "Oh, we didn't know. We were just signing something. We didn't know what it was or whatever." But there's a quirk in Michigan law that requires the electors to sign in the chamber of the legislature, and they realized that they weren't in the chamber of the legislature. They were actually in the basement of the Michigan Republican National Committee, and so they lied. I mean, they just, like, on the document, put false information to comport with the statute, and they were willing to lie about a fact in addition to put their name on it and allow it to be submitted. I just think that's a pretty egregious set of facts, and they absolutely deserve to be prosecuted. I think that's a righteous prosecution, and I applaud the Michigan Attorney General for bringing that case, and for also bringing a very limited, discrete case and allowing Jack Smith to do the rest. Right? She did the people in her state who violated her laws with her election, and I thought that was a great great thing to do. And so that's one of the charges, and that's what, 18 USC 371,
Right. Or
and
as
then
we've
there,
talked about, making false statements,
or
to federal
1001,
agency could be,
yeah, combination.
they're essentially interchangeable there.
And then there's 18
But
USC. Go ahead.
that kind of morphs into the day of, right, January 6th itself, which was the conspiracy to obstruct an official proceeding, the electoral count.
Yeah, is
And
that
so it was,
1512C, 18 USC 1512C, right? I
I
think.
believe it's C, because I think B is
Okay.
witness tampering, which also
Okay.
could be on the table. Although I don't have the code book open in front of me, but I think you're right.
Okay.
It's 18 United States Code Section 1512 has a number of subsections, and that's why I think there's been a little confusion, perhaps in my own mind as well, about when that code is cited in the target letter. I think a lot of people, because the title of that section is tampering with a witness, or again, I don't have it in front of me, but something like that.
Yeah,
A
yeah.
lot of people thought that's what it could be, and that's a possibility. We've certainly heard plenty of testimony, if you're watching the January 6th committee hearings, of witness tampering, including
Right.
of Cassidy Hutchinson, one of the star witnesses, and others. So, we don't know. Once again, we have to keep coming back to this. We don't know everything that Jack Smith knows for sure. We know the tip of the iceberg. So it, could be one, could be the other. But I think my money, and those of my co-authors, is that it also will reflect this other subsection, which, if you're right, I think you are, it's subsection C, which is obstructing an official proceeding. And that, I want to say dozens, scores, maybe even hundreds of January 6th insurrectionists have been charged and prosecuted and convicted under that statute. So that has really held up very well. A number of different arguments and defenses under it have gone up the circuit. They are the DC Court of Appeals, and has been upheld. So that
The official
seems
proceeding being the counting of the electoral votes, trying to
exactly.
get Mike Pence not to certify the election, which is his duty under the Constitution.
Yep. That's it. And there were a number of different iterations and different ways. I mean, there was a very strong pressure campaign against him. There were, along with many of his lawyers, some of whom are disbarred or are being disbarred, who cooked up this idea, that Pence had the constitutional authority to halt the proceedings or to overturn the election in favor of Trump, which those lawyers knew at the time that was lawless and wrong. And so that's another iteration, trying to persuade Department of Justice officials to get in the way and to at least say that there was fraud, to the pressure campaign of various state elected officials. These were all different iterations. But at the end of the day, and on January 6th itself, there was that real-time pressure campaign on the vice president at the time. And then ultimately, there was the breaching of the Capitol and the violence that ensued, which certainly obstructed that official proceeding for a number of hours.
Well, there are some people, some legal scholars who are saying that the speech that Trump gave on the ellipse, where where they said, what's going on? Why is this taking so long? Why, and they said, well, they have to go through the magnetometers. Many of them are armed. And Trump said, throw out the magnetometers, let them through. I don't care that they're armed. They're here to support me. They're not going to hurt me. And to me, and so there are many people who think that speech was the First Amendment, and that he can't be charged with inciting a riot, or at least if he was, that would be legally precarious. I personally don't agree with that view. I think that just those comments, knowing they were armed, just throw out the mags, let them through anyway, and then encouraging these armed, angry people who he fomented their anger, frankly, and he perpetuated this lie. It was like taking a loaded gun and pointing it at the Capitol. This is a crowd. Like, he literally pointed a crowd of armed, violent, angry people at the Capitol, and told them to go. Oh, I hope Mike Pence will be strong. I don't know. I think an aggressive prosecutor, could prosecute that and as not protected speech, as inciting an insurrection, but that was not in the target letter. And then, the other thing is when they breached the Capitol, there's been testimony that he was, sitting in front of the television, and at one point, I guess he threw something and there was ketchup dripping down the wall or something. I don't know. I can't remember. I just remember that visual of, and he so it's not like he didn't know what was happening. People were asking him and begging him to, call in the troops to make it stop, to, call off the people. And for 187 minutes, he's the commander in chief. He has a duty to act. And he sat there and watched the violence for 187 minutes. That's 3 hours, right? 3 hours to sit there in front of the television and watch the United States Capitol. People are breaking the windows, going in, like somebody defecated, he watched all of this, and he sat there and did nothing despite people begging. Not only that, he tweeted, I think it was at 2:44 p.m. He tweeted, he sent out a tweet that actually, calling Mike Pence a coward or the P word. I can't remember now, but I think really just actually just making the matter worse, right? And so I think he can, personally, I would charge him with I wouldn't let him get away with it. Let the jury acquit that charge if it's too, he deserves to be charged with it. He deserves to be convicted of it. Anyway, it's just upsetting to me that he's potentially going to get away with that because, he didn't go in the Capitol. He, made a fake statement about, be peaceful, right? I just think, I think that they're going to be a little bit conservative. The feds are more conservative generally than the state prosecutors. We're a little more aggressive. So
yeah, I would agree with that. But I don't think that Jack Smith is going to let him get away with that.
By the way, Jack Smith started at the Manhattan DA's office in 1994. I started in the Manhattan DA's office in 1992. The Manhattan DA's office had about has about 300 or so lawyers in the trial division, which is where we both started. And the way it's broken up is into 6 equal sections, just for no other reason than because there's like a fire hose worth of, crimes that happen every day and cases come in and every arrest that happens from the NYPD. So you're broken up into 6 equal groupings of people randomly, and that's where you spend your career or your time there. And it's almost like being in a sorority or fraternity. Like, your identity is like, you're either in trial bureau 30 or trial bureau 50, like, and you know what it means. Oh, you're an 80 guy, like, what it means to be in a particular trial bureau, because each one has its own, personality and culture, and it's like being in the trenches, with somebody, because it really is the trenches. Anyway, Jack Smith and I were both in trial bureau 30, and so we were 2 years apart. We were in the same trial bureau. We worked together, and we were trained the same. We came up the same. So, he might be a little more aggressive, just
you
because
might have more insight than most. Yeah, I think, look, he's proven himself to have a steel backbone, and here, what I think is perhaps a genius of charging the January 6th conduct itself under 241, as we've talked about, deprivation of civil rights, is that he can fold in all the conduct that you just talked about, and that witnesses like Cassidy Hutchinson talked about so trenchantly, without having to, invoke potentially that defense, that First Amendment privilege defense. Because so if the charge were inciting an insurrection, there's that defense. And I think before the testimony of, particularly of Ms. Hutchinson, I was a little skeptical. And then when she started talking about exactly what you pointed out, with the magnetometers and knowing they were armed and pushing them in that direction and hoping to go himself in that fight, in the motorcade, all of
turn
that.
the car around.
Yeah, led me to think, okay, I think we have an incitement charge here. But I think putting it in the rubric of a deprivation of rights charge actually defangs that defense. Because what it is, I mean, and there's a long history since, post-Civil War days of that statute being used to prosecute election crimes, whether fraud or crimes of violence. And so what the special counsel will still need to show coordination. That is still, to me, the hardest piece here, only because I'm not privy, of course, to all of the information and evidence that the prosecutors have gathered. Based on what we've seen, there is already evidence of that kind of conspiratorial collaboration. But I'm sure there's going to be some surprises in the indictment, and that will really shore it up. So I think that violence is not going to go uncited or unnoticed or uncharged. Is my best belief. We'll see, maybe next week, pretty soon, I think, sooner rather than later.
So one last thing just about the grand jury is, again, different federal versus state. In New York State, hearsay is not allowed in the grand jury, which actually means live witnesses have to come in and testify under oath, witness by witness. And that can often be a painstaking, difficult process, but that's what New York requires. In the federal system, hearsay is allowed, which means you could have, for example, an FBI agent can go in and summarize the evidence or information that they've taken from people. So, we have a lot of testimony, or I shouldn't say testimony. We have a lot of people who are saying, yeah, the FBI came and spoke to me, but I haven't testified. That doesn't mean that that information isn't, or that conduct isn't going to be included in the grand jury. And, I think Jack Smith, the reason, if you have like a Secretary of State like Brad Raffensperger, who is a public servant who's going to say the same thing over and over, is going to remain cooperative, you might not necessarily have to put that person in. You could just summarize what they say. If you have somebody who you want to get them under oath in the grand jury and make it so that they have to say it there, those are the people I think you put in, right? Or people that you want to give some color to the grand jury. So, for all we know, there's nothing to be gleaned from the fact that certain witnesses have gone in and certain witnesses haven't gone in, because in the feds you can summarize what they say if you've spoken to them. So we don't exactly know that information, based on what we've heard. And so then what will happen is at some point, Jack Smith's people, his staff, or he himself, will go into the grand jury, will read them the law, and then ask them to take a vote. And a grand jury is 23 people, right? At least, or I should say 23 people, and you have to have at least 16 people there for a quorum, which means for an indictment. And you have to get at least 12 people to vote yes to indict. Now, it's not just any of the 12, it's 12 who've heard the material evidence. They have to have been present on the day that all the material evidence was presented to the grand jury. So those 12 people will be, if they can get 12 people to vote an indictment, the standard is less than what it is at a criminal trial, which is proof beyond a reasonable doubt. That's the highest standard. By the way, that's another difference between civil and criminal cases. Is a criminal case, you have to prove, the government has to prove their case beyond a reasonable doubt, whereas in civil cases, it's like 51%. It's more likely than not. It's like you have a scale. I have scales of the scales behind me. If they were exactly equal and you put a feather on one side, that's more likely than not. That's a preponderance of the evidence, and that's the civil standard. I love civil law now that I'm in private practice. I love that new standard, because beyond a reasonable doubt is hard to do, to convince a jury at the end of 12 people of that standard. Boogie's here. Say hello to Boogie, everybody. Boogie's been on our podcast many, many times, and Boogie's just made an appearance. Hi, Boog. Anyway, so that's what's going to happen. He's going to ask them to vote, and if there's reasonable cause to believe, which is basically probable cause, that these crimes occurred, and you get 12 people to vote on that, there will be an indictment. The next thing that happens is the indictment is a written charging document that then, they'll inform Trump and his lawyers, who will then ask them to pick a surrender date. And we assume that's when we'll hear about it, right? And if Trump talks about it, then maybe we'll get another press conference like Jack Smith did last time. I think the reason Jack Smith did a press conference was because Trump came out and talked about it, and so it was like, look, he's talking about it, so I might as well give you information. And then there'll be an arraignment, and we'll go from there, like before, and then you'll have yet another case. Now, we think this is going to be in DC, right? Mm-hmm. And the reason is because you bring cases where they happened, which is, there's something called jurisdiction and venue. The venue is where it happened, which is why we think they went down to Mar-a-Lago for the documents case, even though that went into a Washington, D.C. grand jury originally. I think they figured out that, look, let's take that legal argument off the table, the venue argument, because Trump could say, look, this shouldn't be here, it should be there. And they went down to Mar-a-Lago. But this one, I think, is squarely in D.C. So this will be a D.C. indictment. And so we'll get another judge. Hopefully, they get selected at random. Hopefully we get a good judge, and hopefully that judge will get us a trial before the election. So yeah. What have I missed?
Amongst all the cases that you started out talking right. about, dotting.
Do you think this case could go before the election if it's the three charges you talked about and only Trump? I mean, there's no classified information in this case, we think. So there's no SIPA, the Classified Information Procedures Act. There's no procedures that have to be put in place special to handle that. There's no top secret clearance that you'd have to get the lawyers. Like, do you think this case could get to trial, or do you think it's too complicated for that?
Well, we'll see. what the charges look like. You and I have spent some time now talking about it. I think we both agree it's going to be relatively streamlined. And yeah, if they get the right judge, I absolutely think so. I think there could be a better chance of this one going to trial before the election than the Mar-a-Lago case. I know Judge Cannon in that case just set a May 2024 trial date, but it seemed a little squishy. And as you point out, there's going to be a lot of issues, and they're going to raise them all. So I think there's more room for mischief in that case than in this one. But
Yeah.
I do think we'll see soon enough.
Well, I think we need to wrap up this one a little longer than I promised you, and I'm sure you're very busy since you have to get ready for your deposition of Donald Trump in the next 43 days, which is incredible. And I want to thank you so much for coming. This is really important, this case. The thing about this case that is so much more important, I think, than all of the other cases is the foundation of our democracy is all about the ability to cast a vote and have the person who you voted for or the most people voted for win. And that's what it means to live in a democracy. And when your person didn't win, you accept that and you go along with it, and you peacefully transfer power, and we all as citizens live with the person we didn't vote for, the person we did, and we live together. And that is the absolute essence and foundation of our democracy, of the United States of America, and of what we preach all around the world, right? We uplift democracies in countries. We teach third world countries and hope to get them, to be democracies and help them. And, this is what we preach. And you had Donald Trump, who just didn't want to give up the presidency. He didn't like that he didn't win. And he absolutely lied about, he went to court over 60 times and lost every single one, trying to convince people that, there's fraud, there's lies, there's deception, there's, dead people voting, whatever. And none of it held up. None of it. He even had the Department of Justice under Bill Barr investigate these claims. Bill Barr has said, we investigated them. This was his attorney general. We investigated them. And, and Trump wouldn't accept no for an answer. And so he started making up lies. He has convinced a lot of people of these lies. And then he tried to stop the peaceful transfer of power. If there is not a more serious crime than that goes to the fabric of the United States and our democracy, I don't know of a more serious crime, because frankly, without our democracy, without our freedom, without our laws, we're nothing. We're truly nothing, and nothing else matters if we don't have that. So, to me, this is the most important case. I applaud Jack Smith and the Department of Justice for bringing it. I credit the January 6th Select Committee for kicking them in the pants, because frankly, the Department of Justice was not looking at this as seriously until then. And so thank God that they wanted to set the record straight, and they did that important work. They should go down in history as heroes for doing that and for raising the national consciousness. And, so I look forward to this indictment coming up. Danya, I'm going to give you the last words. What do you want to say?
Oh, I just couldn't agree with you more. This is foundational, if not existential. So I think, all Americans should be watching and waiting, and so should the world be. I'm with you in applauding the work of the January 6th committee. I do think, you asked the question, can this be tried before the election? It is unfortunate that it took so long to get it started. I don't blame Jack Smith for that at all. He wasn't even appointed. But he's been, going all in since his appointment. And it seems, again, going back to the beginning of this conversation, we are all reading tea leaves here. But it looks like this is happening soon, and hopefully it will be done before this election. We'll see.
There's no one I'd rather read tea leaves with than you, Danya. So thank you so much for joining us today and for all of your time. We really appreciate it.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.